enforcement in this inconsistent, even inaccurate way. Return again to the language of 13 parentheses 3. The only requirements were that the board had to determine that the circumstances were unusual and extingent, something they had already done in the case of Bear Stearns in March 2008, and the loans of the Lehman Brothers had to be secured to the satisfaction of the Federal Reserve Bank, something that was left to reserve banks to determine. If the Fed's lawyers approved the loan of the Bears but not Lehman, it reflects an extraordinary amount of unreviewable power in the hands of the public, has no input in selecting. The statute gives ample discretion to make those determinations, which means something other than the law is dictating the decision-making authority. If the Federal Reserve Act is interpreted by the Fed's in-house lawyers, as Bernanke and Geithner have said, then this is a remarkable delegation of the federal policy on the hands of central banking lawyers. Perhaps there is no avoiding the importance of lawyers making quick and controversial policy judgments as they interpret the law during a crisis. Another aspect of the Fed's lawyers. Crisis practice is laminatable and impedes meaningful public accountability without any obvious benefit, and that it is so-called doomsday book, a secret complication of legal authorities, precedents, and authorizations available to the Federal Reserve to use in a crisis. That former New York President Tim Geithner called the Fed's actual firefighting equipment. There are, it appears, 3 versions of this book, one in the financial crisis of 2008, but 2 others that have been updated to reflect the changes in law in 2012 and 2014. What are these authorities? Question. Are the legal interpretations defensible? Question. Did the Board of Governors endorse them? Question. Have the governors read them? Question. The public doesn't know. And here, the influence of the authors of this book, almost certainly the Fed's lawyers on the Fed's institutional geography, is at its most powerful. A double government indeed. Ideologies of regulation, the case of Scott G. Alvarez. Next paragraph. The crisis enhanced the status of the Fed's lawyers, not only because of the questions about the in-the-moment authority, but also because the legislative response to the crisis was so overwhelmingly detailed as a result. There is an outside role that lawyers play, not only in enforcement and statutory interpretation, but in the formulation of regulatory policy generally. The Dodd-Frank Act of 2010 is a perfect example of the staggering scope of agency influence, not in simply enforcing the law, but in writing it, the act of a huge piece of legislation, but also a dramatic delegation to the administrative agencies of defining the scope of applicability of the law, because the Fed is the first among equals as a financial regulator. Much of the authority falls to the Fed, and because the Fed's lawyers are the staff primarily in charge of overseeing and the implementation, the ideologies and values of the Fed's chief lawyer is highly relevant to understanding how the Fed will define the space within which it makes its policies. Page 98. During and after the crisis, the chief lawyer called by some of the Fed's 8th governor was Scott G. Alvarez. Alvarez spent much of his entire career as a Fed lawyer, becoming the general counsel under Greenspan in 2004. Even with a governor like Daniel Tarullo taking over so much of the Fed's legal apparatus himself, Alvarez has a major role to play in the implementation of Dodd-Frank's regulatory authorities. As one regulator put it, Alvarez is a major player in everything. You can't overstate his role. Everything has to go to him for approval and to be passed on. Given that authority and influence, it is important to get a sense of the power behind the throne. Quotes. As one profile termed it, Because of the secrecy within the Federal Reserve System generally and around its lawyers specifically, though it is difficult to discern exactly what Alvarez views on the regulatory matters, he goes on record with his views and theories of regulation very rarely, almost never. An exception in his interview for Financial Crisis Inquiry Commission, a fascinating tour through a Fed's lawyer's take on banking history, theories of risk, and the 2008 financial crisis. The most important upshot from Alvarez's interview in that regulators aren't to blame for the financial crisis, nor is deregulation generally. For example, only one key debate following the crisis was how much the political and regulatory climate in the 1980s and 1990s contributed to the financial crisis. During those decades, there was significant enthusiasm to remove New Deal era restrictions on the kinds of activities that banks and bank holding companies could engage in. Under the New Deal model, banks had to choose between being commercial banks, accepting deposits, interacting with consumers, and being investment banks, advising clients and facilitating access to capital markets. In the Banking Act of 1933, known for the co-sponsors Carter Glass and Henry Steagall, banks couldn't do both. In 1999, both after the decades of the agency and judicial whittling down of the Glass-Steagall restrictions, the wall came down as Congress passed the Financial Services Modernization Act, better known as Gramm-Leach-Bliley for its congressional sponsors. Gramm-Leach-Bliley essentially repeated the almost 70-year-old Glass-Steagall afterward. Banks could and did grow much more. In the wake of the financial crisis of 2008, many criticized the deregulatory impulse, including the repeal of Glass-Steagall for contributing to the crisis. Scott Alvarez is not among them. The argument given in his testimony is that the firms that represented the biggest threat to the system, Bear Stearns, Lehman Brothers, AIG, Freddie Mac, and Fannie Mae, for example, weren't the ones that benefited from the repeal of Glass-Steagall's demise in the first place. So the problem was very different. But Alvarez went further. Not only did Glass-Steagall's repeal, because the crisis, Alvarez also rejected the idea that the repeal exasperated the crisis at all. It's a defensible view that the financial crisis of 2008 owed itself to other factors beyond the Glass-Steagall's repeal. Here's Alvarez's point is a good one. But to say the deregulation and subsequent dramatic increase in the size of banks' balance sheet and nothing to do with the crisis misses two key points. First, the crisis was extraordinary not only because the financial institutions on the first line of failure, not the one affected by Glass-Steagall's repeal, imploded, but because their counterparties in the rest of the financial system were next in line. The case in the point of the Citigroup, the entity whose very existence in present form owes itself to the fall of Glass-Steagall. Even if we accept Alvarez is the correct, Glass-Steagall wasn't the salvation of the financial system. The rest of his testimony defending the proposition is a steady march of arguments about why the Fed and its regulatory apparatus in 1980s and 1990s had little, if anything, to do with the crises. The two propositions and related Glass-Steagall's demise didn't come at a stroke, but through the decades of decisions within the Board of Governors and other banking agencies supported by courts to provide the fewer restrictions on number of different activities with direct relevance to the financial crisis, the role of the federal banking regulators in facilitating. Page 100. The breakdown of the risk control is an essential part of the story of the financial crisis. One wouldn't know this from Alvarez's retelling. The closest he comes to admitting regulatory failure is that the fractured nature of the federal banking regulation in which agencies share regulatory authority meant that regulators had a hard time understanding where risk was concentrated in the system. Even Alan Greenspan could admit to greater regulatory failings than that. Indeed, at one point, the interviewer states what is objectively true. Banking regulators in 1980s and 1990s participated in the erosion of various regulatory standards through the interpretive and enforcement authority that was increasingly liberal in the interpretation of key statutory restrictions. Even this historically inescapable conclusion is too much for Alvarez. These activities were found by the courts to be permissible. He corrected the interviewer. Bank regulators shouldn't be responsible for what the courts decided. Of course, he concedes. Courts wouldn't have had to deal with that problem if the agencies didn't take action. But in the end, the courts were the deciders. Alvarez is correct. To bring courts into a discussion of deregulation, a key but underdeveloped part of this book's story is the role that courts play in defining the Fed's policy-making space. This doesn't mean that courts don't matter, especially in the context of administrative law and regulation. Doctrines of agency deference have given the Fed and its lawyers the latitude to use their own ideas to give content and sometimes abstruse statutes to oversimplify a vast set of legal doctrines and cases and scholarships, interpreting them under the canonical standards. When Congress writes an unclear statute, that the agency tasked with clarifying the statutory content gets leeway from the courts to chart their own path. Consider it through that of Alvarez's statement means here. A bank regulation from the Fed's Board of Governors and its lawyers authorizes the erosion of some relevant standard that has a direct implication of the financial crisis. Following long established doctrines of deference to an agency's action, a court neither endorses nor condemns that interpretation but lets it stand. And because it does, the court, not the regulator, is responsible for the outcome. That's a stunning theory of agency responsibility. It is easy to run the opposite direction and blame Alvarez for too much. He has always had a boss in the Fed chair and Board of Governors, and ultimately responsibility for any failures or successes cannot lie squarely with him. But given how much power the Federal Reserve Act has, the Dodd-Frank Act give the Board of Governors and lawyers who advise them in shaping federal policy, it is important to know who these lawyers are and what they believe about the statutes, regulations, and policies they are assigned to interpret. Here, the Ulysses Punchbowl theory of Fed independence, with its emphasis on technocracy and its insulation from politics, is worse than useless. These judgments about the permissible scope of banking activities and the requirements of law are not exclusively, perhaps not even mainly, technocratic judgments. They reflect the values of people making them because the Fed's board and its staff lie under a uniform, mystical blanket of federal independence. It can be difficult to discern exactly what those personal values are. Conclusion, paragraph. That institutional insiders exercise extraordinary influence over the policy is not news. Some of the earliest critics of the administrative state worried about the bureaucrats shielded from democratic accountability. The defense of these kinds of technocratic, meritocratic positions was the alternative, a political spoils system whereby incoming administration could summarily fire its predecessors' appointments, was wasteful and corrupt. What the discussion in this chapter suggests is that there is a line between the exercise of technocratic judgment and the value judgment that gets crossed higher within the Fed. A technocrat rises. This chapter has focused especially on the General Counsel, given the lack of reviewability for his decisions, and the experience of Edmund Truman, given extraordinary position to influence national policy. Page 102, end of chapter 4. Well beyond the Fed that he exercised during the crisis of the late 1990s, the question we will leave to the book's final chapter is whether the current failure to subject the staff leaders to presidential appointment is appropriate, given the authority they exercise. The Fed's chief economists approach that line in light of the financial crisis. The Fed's chief lawyer crosses it.